Hello and welcome to 2025 Healthcare Risk Management Week. We are excited to share this year's mock trial, which is based on a fictitious medical malpractice case. We invite you to be the jury as we take you through the trial in an abbreviated fashion. At the end of this week, you will have gained insight about the trial and jury process, and we will ask you to submit your verdict at the end of the trial. This is a case about Mr. Michael Polson, a 30-year-old male who presented to the ED with severe back pain and nausea following vigorous exercise. He briefly mentioned chest pain, which he attributed to a spicy meal. He had stable vital signs, an unremarkable chest X-ray and EKG findings, and his condition was characterized as gallbladder-related after an ultrasound showed sludge. Aortic dissection was ruled out due to his age and lack of risk factors. Throughout his ED and IMC stay, communication lapses occurred about key details of his worsening pain, the character of his pain, and blood pressure changes. Although the patient later revealed a family history of aortic dissection, there was continued focus on gallbladder disease and lack of escalation of this new information. During the inpatient admission, Mr. Polson deteriorated, experiencing sudden chest pain and unresponsiveness, and he could not be resuscitated. The plaintiff alleges that the healthcare providers were negligent in failing to properly rule out and/or diagnose an aortic dissection for Michael Polson, leading to his death on the day after admission. Let's hear from the judge.
As you know, this is a case of alleged medical negligence. Plaintiff Mrs. Rachel Polson, the wife of Mr. Michael Polson, has filed a lawsuit claiming that the healthcare providers were negligent by failing to properly rule out and/or diagnose an aortic dissection when Mr. Polson presented to the emergency department and during his inpatient stay, leading to his death the following day. More specifically, the plaintiff claims that the emergency medicine physician, Dr. Timmons, the inpatient resident, Dr. Miller, and the inpatient attending, Dr. Kendrick, failed to timely diagnose and treat Mr. Polson's aortic dissection, and that Nurse Anderson failed to adequately escalate her concerns about Mr. Polson's condition. Lawyers for each party will make an opening statement and a closing argument. Each party will testify. You will hear from the plaintiff, Mrs. Rachel Polson, Mr. Polson's wife, and the defendants, Dr. Anna Timmons, Dr. Thomas Kendrick, Dr. Jamie Miller, and Nurse Carrie Anderson. Each party will also call expert witnesses. You will hear testimony from experts in emergency medicine and cardiothoracic surgery. As the jury, it is your job to determine whether the plaintiff has proved their claims of negligence by a preponderance of the evidence, meaning more likely so than not so. Negligence is defined as the failure to meet the standard of care or what a reasonable healthcare provider would do under the same or similar circumstances. Whether or not the provider met the standard of care is your decision, and you will be assisted with that decision by the expert witness testimony I talked about. If you find negligence, you must then determine whether that negligence caused or substantially contributed to Mr. Polson's death. If so, you will then decide how much should be awarded in compensation. First, I'm going to briefly instruct you on the law. After that, we will turn it over to counsel for opening statements. Ladies and gentlemen of the jury, as we begin this trial, it is my duty to instruct you on the laws that apply to this case. It is your duty to apply these laws to the facts as you find them from the evidence presented. You will hear testimony from witnesses. It is your role to determine the credibility of each witness. In doing so, you may consider the manner in which they testify, their interest in the outcome of the case, and any other factors that bear upon credibility. The plaintiff has the burden of proving their case by a preponderance of the evidence. This means that you must be persuaded, considering all the evidence, that what the plaintiff claims is more likely true than not true. Negligence occurs when a healthcare provider fails to follow the standard of care that a reasonably competent provider in the same field would have followed under similar circumstances. For the plaintiff to recover damages, they must prove that the defendant's negligence was a proximate cause of the injury. Proximate cause means that the negligence was a substantial factor in bringing about the harm. If you find for the plaintiff, you must then determine the amount of money that will fairly and adequately compensate them for their injury. Your verdict must be unanimous. All jurors must agree to the verdict. It is now time for opening statements. Because the plaintiff has the burden of proof, they go first and have the chance to have the last word as well. I will now turn it over to plaintiff's attorney, John Fischel. Mr. Fischel?
Good morning, ladies and gentlemen of the jury. My name is John Fischel, and I have the privilege of representing Rachel Paulson, the widow of Michael Paulson. Mr. Paulson is not here today. His wife is here on his behalf. He's not here because he passed away on April 23rd, 2023, due to the negligence of the defendant healthcare providers. Let me tell you a little bit about Mr. and Mrs. Paulson. They live here. They met here. They were high school sweethearts. Mr. Paulson, 30 years old, was an engineer, the youngest vice president of Whiting Turner. They were about to start a family together. One morning, Mr. Paulson, while his wife slept, went to the gym like he did every morning. He worked out. He started to have some chest pain. He got home, the chest pain didn't go away. He continued to have this pain, so his wife and him did what was reasonable. They went to the emergency room. They went to the emergency room at the University of Maryland to be seen to have healthcare providers take care of him and look at this chest pain and determine what the cause of that chest pain was. You're going to hear a lot of evidence in this case from Mrs. Paulson, from the healthcare provider defendants, from standard of care experts, from emergency medicine, cardiothoracic surgeons. But you're going to hear that when Mr. Paulson presented to the emergency room, he had clear signs of what's called an aortic dissection, a life-threatening condition that ultimately took his life. You're also going to hear that that condition was ignored, essentially ignored by these healthcare providers as he sat there and ultimately died from that condition. An aortic dissection, everybody probably knows what the aorta is. It's the largest vessel in your body that carries blood throughout your body to the heart. A dissection is what it sounds like. It's when the lining of that aorta tears. And if that's not, it's a medical emergency, and if it's not cared for emergently, you will die from it. There are certain signs and symptoms of having an aortic dissection. One of them is vomiting, which Mr. Paulson reported to the emergency room doctors that he had experienced when he was having his chest pain while he was working out. The chest pain also comes with severe back pain that's often described as a ripping pain. A ripping pain is considered one of the classic signs of an aortic dissection. You're also going to hear that Mr. Paulson had a family history of having an aortic dissection. A family member, also a young family member, had died from an aortic dissection years before. Mr. Paulson shows up at the emergency room and he's seen by Dr. Anna Timmons. Dr. Timmons did do tests, but there are two tests that Dr. Timmons decided not to do. One is a CTA, which is an imaging film that is used and will, if it had been done, diagnose an aortic dissection. The other test is called a transesophageal echocardiogram. Again, another easy to perform test that, had it been done, would have shown that Mr. Paulson had an aortic dissection. Neither of these tests were done by Dr. Timmons because she was anchored in on this idea that his symptoms were either workout related or were due to a sludge in his gallbladder. Both of these turned out not to be true. We know what was causing Mr. Paulson's pain, his excruciating pain, was an aortic dissection that was essentially being ignored. You're going to hear that Dr. Timmons, while she did order tests, there's one thing Dr. Timmons didn't do. Dr. Timmons didn't read the notes from the nurse taking care of Mr. Paulson that reported Mr. Paulson's pain increasing and also reported Mr. Paulson describing his pain as that classic ripping pain. Dr. Timmons is going to tell you she didn't bother to read the nursing note. Because Mr. Paulson's pain hadn't subsided, he was admitted to the medical floor. He was seen by a resident, Dr. Jamie Miller. Dr. Miller, we'll hear, purportedly examined Mr. Paulson when he showed up at the emergency room, on the floor. But, we don't know what his exam found. Why not? Because Dr. Miller, instead of writing the findings down, including Mr. Paulson reporting a family history of having an aortic dissection, simply cut and paste the note from the emergency room. So all of the providers, Mr. Miller's senior doctor, the attending doctor, Dr. Thomas Kendrick, didn't even know that there was a family history or a ripping pain. Mr. Paulson was also seen by a nurse, Anderson, while he was on the floor. Nurse Anderson was caring for him, and Mr. Paulson continued to be ill-appearing. His condition was worsening. His blood pressure was going dangerously low. And she texted, got on what's called a Tire Connect system, and reached out to Dr. Miller to let him know about these concerning signs. She didn't go see Dr. Miller. She didn't go tell Dr. Kendrick. She used this texting system. You're going to hear that Dr. Miller doesn't bother to read the texts. He received it. He acknowledges he received it. He acknowledges that it contained information that he would want to know, but it was too long, so he decided not to read it. As a result of all of these failures, these communication failures, these ignoring of signs and symptoms that are classic for an aortic dissection, Mr. Paulson is no longer with us. You're going to hear from various experts in this case. I, as the plaintiff's counsel, have the burden of putting on the case for you and showing, not to a criminal standard of beyond a reasonable doubt, but that more likely than not, these healthcare providers violated the standard of care that's doing what is reasonable, and that their failure to do so caused Mr. Paulson's death. You're going to hear from multiple expert witnesses who are going to testify that these failures that I've outlined certainly weren't reasonable. And I think it is undisputed, the undisputed testimony you're going to hear is that the failure to treat what was a treatable condition caused the death of Mr. Paulson. After you've heard from all these medical providers in the testimony, I'll be back up here with what are called closing arguments. At that time, I'm going to ask you to award a sum of money that's not going to bring Mr. Paulson back, but is the only way to compensate his family. So as you're listening to these witnesses, I want you to keep that in mind, because I think the one thing you're going to hear, and keep in your mind the term reasonable, was what these providers doing reasonable? I think you'll find the answer was no.
Good morning. My name is Ed Brady, and you may recall from the judge's introduction earlier that I have the privilege of representing the defendants in this case. Ladies and gentlemen, you are now performing what Winston Churchill once called the most noble duty a citizen can perform during peacetime. You're serving as a juror. And that role that you are asked to perform in the course of this proceeding is difficult. Sitting in judgment of people you don't know and events you didn't witness is never going to be easy. But as you embark on this role, I'd ask you to keep in mind a couple of things. And I'd ask you to bear in mind how important your role is in this process. You see, what we do in this room and what we do in this building is not justice simply because we call it a courthouse. Rather, what happens in this room can fairly be called justice only because people like you give their time and their energy and their commitment to making sure that the result is just. So having said that, let me take an opportunity to thank you, but not on behalf of myself or even my clients, and not on behalf of my colleague, Mr. Fischel, or his clients, and not on behalf of the court. Rather, I want to thank you on behalf of what the Constitution collectively calls we the people, because it's for we the people that you do this. It's not for us. This is our system of government, and it's our system of justice. And that system, despite what you might read in the newspaper or hear on the radio or see on the TV, does work. And it works every day around this great country because people like you make sure that it works. Now, I want to talk to you. This is my opportunity to talk to you about the evidence in the case that we think the evidence as we think you're going to see it in this case. This is not my opportunity to argue to you. That comes after the close of the evidence when I'll return and speak to you about closing arguments. So before we talk about the evidence, let me suggest to you two things you should keep in mind. Number one, keep in mind that you're evaluating this evidence in retrospect, and that's okay, but it's hard because the defendants in this case, Dr. Timmons, Dr. Kendrick, Dr. Miller, and Nurse Anderson, didn't get the benefit of evaluating the evidence in retrospect. They only get to evaluate the evidence in real time. They make critical clinical decisions based upon information available to them at the time. That's very much unlike what happens in this courtroom. So it's important for you to understand and recognize and appreciate that distinction. When my colleague, Mr. Fischel, was speaking to you in his opening statement, he said something that I thought was pretty important. He said repeatedly, "We know." The words "we know." And he said, "We know that Mr. Paulson had an aortic dissection." He said, "We know that." But we know that now. The doctors and nurses who took care of Mr. Paulson at the time on April 22nd, 2023 did not know that. So it's important for you to recognize that just because we know something now doesn't mean it was necessarily something that was easily determined at the time of Mr. Paulson's care. In evaluating the evidence you're going to hear over the course of the trial, also remember that it's important to consider all of the evidence. It's important that you not reach conclusions in your own mind before you've had the opportunity to hear all of the evidence. And that includes the evidence that will be presented by the plaintiffs, not just the evidence from the defendant. But because the plaintiff goes first, it's important for me to remind you that you should not form opinions about what happened in this case until you've heard all of the evidence. Because as you know from life, there are always two sides to the story. Let me talk to you a little bit about the evidence so that the sooner I can finish talking to you, you'll hear from the witnesses themselves. So you're going to hear from, as we've indicated, my client's Dr. Timmons. She was the ED attending who saw Mr. Paulson when he presented to the emergency department that morning with his wife on April the 22nd of 2023. You're also going to hear from Thomas Kendrick. He was the IMC attending who treated Mr. Paulson once he was transferred and admitted. Transferred from the ED and admitted to the hospital. You'll hear from the inpatient resident who handled the admission of Mr. Paulson, and that's Jamie Miller. And you'll hear from the IMC bedside nurse, Carrie Anderson. You're also going to hear testimony from expert witnesses. Now, bear in mind that expert witnesses have had ample time to sit down and review medical records and study the medical issues before they testify or author reports in a case like this. And that doesn't make them incredible. Both sides have expert witnesses. Both sides pay expert witnesses for their time in presenting their testimony. But you should evaluate the testimony of expert witnesses, understanding that they have had the opportunity to evaluate the facts in this case in the calm collective of their offices, not in the real-time emergency department or hospital setting. I also want to discuss with you, if we can for just a minute, an important concept about evidence. Evidence is often what you hear in a case, what you see, what the lawyers present, and what the witnesses testify to. But there's another concept that's just as important, and that is oftentimes the best evidence is evidence you don't hear. That is, things that didn't happen. Now, you heard the plaintiff's counsel say in opening statement that Mr. Paulson was ignored and that his symptoms were ignored. And I'll respectfully submit to you that that's not correct. And the evidence in this case will not establish or demonstrate that Mr. Paulson was ignored. On the contrary, what the evidence will establish is that Mr. Paulson underwent a thorough workup and evaluation, both in the emergency department and when he got to the intermediate care unit. What you'll hear is that Mr. Paulson, far from being ignored, actually underwent 3 different tests in an effort to help to try to determine what was causing his presenting symptoms. He underwent an ultrasound, he underwent an EKG, and he underwent a chest x-ray, all of which were normal. All of his vital signs were normal, with the exception of a progressive, at some point he developed a progressive hypotension, a low blood pressure later in the course of his care. But for the most part, his vital signs remained normal, and the diagnostic testing that was done did not reveal results confirming a diagnosis either way. However, what it did reveal in the ultrasound was something called sludge. And that sludge is an indication of gallbladder disease. And the interesting thing that you'll hear from the evidence in this case is that gallbladder disease, and as indicated or manifested in sludge, which was identified in this case on the ultrasound, can manifest itself in symptoms that are very much consistent with what you might see in an aortic dissection: severe chest pain, shoulder pain, nausea, and vomiting. In this case, Mr. Paulson had reported that he experienced the sudden onset of the pain that he presented to the emergency department for after a workout. It was not unreasonable for providers in the emergency department to include in their differential diagnosis the idea that he had suffered an injury during the workout, a muscular injury. It was also not unreasonable for, as the evidence will establish, for the providers to consider gallbladder disease as one of the leading potential reasons for his presenting symptoms. You've heard me use the word reasonable several times, and it's important for you to understand what you're asked to decide in this case is whether or not the providers acted reasonably. It's a difficult concept sometimes to explain to jurors what maybe you consider a little secret of the emergency department. And I'll let you in on that little secret, and that is emergency medicine providers don't always know what's wrong with you. That's right. They don't always know what's going on. And they can't always determine that when you come into the emergency department, and they can't always determine that just because you're admitted to the hospital for further observation. Oftentimes what providers are able to do, and sometimes the best that providers are able to do, is come up with a working theory as to what's going on with you. And they, through a process of diagnostic evaluations and observation and trial and error, they come to a conclusion about what they ultimately think is going on with you. And in that way, it's important for you to understand that what you're being asked to decide in this case is not necessarily whether the providers were right. It's whether they were reasonable. And that is an important distinction that you'll need to keep in mind as you evaluate the evidence in this case. And we believe that when you do evaluate the evidence in this case, you will come to the conclusion that the defendants acted reasonably. It doesn't mean they got it right. They may not have, but it does mean that they acted reasonably in the evaluation process of trying to determine what was causing Mr. Paulson's presenting symptoms. When you've considered all the evidence, we believe that you will come to the conclusion that although tragic and unfortunate, Mr. Paulson's death was not the result of medical negligence. The providers in this case acted reasonably in trying to provide the best care they could for Mr. Paulson under the time constraints and the information constraints that they operated under at that time. And we'll ask you at that time, when I return to speak to you at the close of the evidence, I'll ask you to consider the evidence that you will have heard by that point, and we'll ask you to return a verdict in favor of the defendants. Thank you.
Today, the plaintiff and defense attorneys highlighted what will be the basis of their case. As we had mentioned, the mock trial is a very abbreviated version of what a trial would be. Realistically, the way that day one works, you spend the majority of the day picking jurors. On day one, you might start opening statements, but you might not based on the length of the trial. The substance of the opening statements can look different and can depend on the details of the case, the style of the lawyer, and the purpose is to tell the jury what you believe the evidence will be as it will be presented over the course of the trial. Today, you heard about the burden of proof in medical negligence cases, a type of civil litigation case. The plaintiff must prove that it is more likely than not that there was medical negligence that was the proximate cause of the plaintiff's injury. This is a lower standard than a criminal case where the burden of proof is beyond a reasonable doubt. In this case, you see that members of the clinical team from differing disciplines are named. If you're wondering who can be sued in a case, this can be anyone who has established a duty to care for the patient, whether an attending, resident, nurse, or others caring for the patient. For this case to move forward, the plaintiff must have an expert in the same or similar field who supports that the case has merit. Today, you heard about how cognitive bias will be a relevant factor in the case. There are over 100 identified types of cognitive bias, and certain characteristics can increase the chance of cognitive bias, such as complex workflows, being short on time, cognitive loading, and your own feelings. Some of the cognitive bias that could have been at play in this case are premature closure and anchoring bias, meaning that the clinicians were sticking with the initial diagnosis made and the failure to consider alternative diagnoses once gallbladder disease was thought to be the patient's issue. Encountering rudeness has also been shown to have an effect on narrowing one's perspective. Things like simulations and case studies can be helpful in overcoming cognitive bias and avoiding cognitive error traps, routinely asking, what else could it be? And taking the time to thoughtfully appreciate how cognitive bias can contribute to errors in your own clinical work can be very impactful as well. Thank you for joining us today. Tomorrow we'll hear the plaintiff's case. See you then.